Hi there, students. In today's lecture, I wish to discuss about other aspects of waste management law of our country, that is India. The first and foremost management rules that I wish to discuss is 2001. I'm not picking 2016 though. I have started with the 2001 regulations because these rules primarily lays down the basis of waste management and handling, not just with respect to batteries, even with respect to other areas. And I insist you people to look into the 2016 rules, which I think in the last lecture I did a bit of comparison as regards the hazardous waste management rules. However, I will also, refer to the 2016 rules while discussing the 2001 rules. Now, starting with the batteries management and handling rules of 2001, it basically applies to all the manufacturer, importer, reconditioner, assembler, dealer, recycler, auctioneer, consumer, and bulk consumer involved in manufacturing, processing, sale, purchase, and use of batteries or its components. Let me amaze you with the fact that our country, India, it is, I would rather say, more than legally, it's an illegal hub for several recycling lead acid batteries. And many of these things are recycled and exported to other countries. Now, recycled lead acid batteries, government has sanctioned only prescribed. There are certain limits also from the side of the government with respect to registered recycler of these lead acid batteries. However, more than that, we have unregistered illegal lead acid battery recyclers across the country. Now, when you're dealing with something which is relating to batteries, which in fact contributes to many of these gadgets and gizmos and other equipments, electronic equipments which we use in our day-to-day life, because in a way these things are powered by these batteries, and it's up on our usage only. So don't confuse it with electronic waste management though, because for that it is different area. This is only confined to several kinds of batteries, and because you're using a lot of technological equipments, like laptops and mobiles, and they do all run by batteries. Now, there are certain responsibilities, just like the hazardous waste management rules. Even under the 2001 rules, there are certain responsibilities of manufacturer, importers, assembler, and reconditioner of batteries, which in fact includes collection of these batteries. So the thing is that the used batteries are basically collected back as per the schedule of these rules, which is against the new batteries sold, excluding those sold to original equipment manufacturer and bulk consumers. All these manufacturers, importers, assemblers, reconditioners. So basically, when I'm referring to just manufacturer, when I'm saying that, I mean all of them. They also have to ensure that the used batteries which they have collected back are of similar type and specifications as that of the new batteries which are sold. I don't know how far it's happening all around, our country, but unfortunately, the challenge still remains. There is a procedure for filing of half-yearly returns also. The number of the sales and the buybacks of these batteries in a prescribed form, the Form 1 of this given rules, latest by 30th June and 30th December of every year. This is what the law prescribes. In fact, the law also talks about setting up of collection centers, either individually or jointly, at various levels for collection of used batteries for consumers or dealers. I would like to point out one thing that I know these are the online lecture series, and in this online lecture series, what I'm doing over here is I'm sharing the legal information, case laws, etc. What is their law in principle? Some case laws, of course, not some. I think quite a few case laws, and on the top of that, I'm also kind of emphasizing on some provisions which are kind of very critical also. The thing is that, this is, I believe, a drawback of online lectures, as it's a kind of a bit monotonous at the same point of time. When you're in a regular classroom lecture, you can have some critical appraisal of the same, which I think I'm missing this time. However, I insist there are a number of articles available on ResearchGate, on Google Scholars, which are accessible. In fact, please do refer to these articles for critical appraisal of it. I understand that in this given point of time, you guys are also struggling. So hopefully in the days to come, if you find any interest with respect to these topics that I'm discussing, maybe it related to your project topics and all this time, I will have to be really lenient also at the same point of time, because many of you don't have access to the online database. But I still insist that read those secondary sources, articles also of your choice. And as I've already mentioned in the class, that I always insist students to choose one article of their own. I'll definitely give one or two, but the thing is that you have your own level of difficulties as a benchmark also at the same point of time with respect to scholarly articles. So I don't want to share some very highly scholarly articles which many of you or maybe some of you will struggle to understand and comprehend. So I have always given you that liberty to choose an article of your choice. But still, I have been kind of sharing few articles also on our online platforms. So I'll do the same if I come across any, which I believe, because I have quite a few, and I'll share. But still, I also insist you guys to refer to certain articles which are late journal, for example, seven articles, and ELRC publications. They are also with respect to these things. Now, coming back to the discourse. These used batteries collected are sent only to registered cyclers. Necessary arrangements have to be made with the dealers. No damage to the environment should be done while you transport these batteries. They should also undertake several public awareness campaigns. I believe there's a lot of responsibilities that have been bestowed upon these recyclers, manufacturers, dealers, etc., etc. So, how far they have comprehended and tried to really, implement it, so that I believe there's a big, gray area which I'm quite sure they are not doing. So they have to also ensure that they are putting all the international recycling signs, on those used batteries. They also have a duty to bring violations by the dealers to the notice of the State Pollution Control Board or the central government, so-called the Ministry of Environment, Forest and Climate Change, and they have to also ensure that these new batteries are sold only to registered dealers, unfortunately, which is not happening. There is an article, you can find it on the India Environment Portal, which is a wing of Center for Science and Environment, where you will get that, the news article on India's illegal lead acid batteries and its so-called dealers. With respect to imports of batteries, as I've already mentioned, that India is one of the major importers of these batteries, and they recycle it and send it across and export it. So all the importers of the batteries have to get registered as per Form 1 or with the Central Pollution Control Board for a period of 5 years. That's the timeline. That's the validity of their registration. Renewal of the registration will be done, but it is subject to the status of the compliance. So if they have complied with the rules, they will definitely get renewal. If they haven't, well, they won't. Custom clearance of import shall also be consistent upon the valid registration with the Reserve Bank of India and the one-time registration with the Ministry, according to Form 11. With respect to dealers, there are certain prescribed responsibilities. These are basically to ensure that these used batteries are collected back as per the schedule against the used batteries sold. They should also give appropriate discount for every used battery returned by the consumer. They have to register themselves with the SPCB for 5 years, and any failure in compliance, which was also there for the manufacturers, well, it will result in cancellation of their respective licenses. There are other responsibilities also, which basically includes sharing information which at the same point of time safe transportation and preventing any damage to the environment while transferring or transporting the used batteries. Same goes with recycler. They have to also apply for registration. They have to also ensure conditions of the registration with strict compliance. They have to file annual returns as per Form 7 to this SPCB, and all these records which they maintain, which is of course they have to make it accessible to the SPCB for inspection. These are the things, and in fact they have to also mark it as recycled, whatever lead recovered, with respect to the batteries. They have to mark it as recycled once they are done recycling the same. When it comes to consumer like you and me, it can be individual consumer, it can be bulk consumer. All these consumer, they shall not dispose of in any manner other than disposing with the dealer, manufacturer, importer, assembler, registered recycler, reconditioner, or at the designated collection centers. They have to. So how far we are doing it. That is something. In fact, if you're aware, even with respect to electronic waste management, if you go for a new laptop in the registered, outlet, then you have this. Just check with the dealer next time, or sorry, the seller next time, or the retailer next time. Once you go for a new laptop, they have a provision that I want to sell my old laptop to you. Even online, we can do that, and you get an exchange discount, right? So this is basically in a kind of recycling. Now the thing is that as a consumer, we should also be aware of these collection centers. There are designated collection centers. Unfortunately, we don't. In fact, I'm pretty sure if you just go for a survey in our own university itself, I'm not sure how many of you are aware. In fact, I was not also aware previously before I got to know about this law. So there is with respect to the consumers, and of course for bulk consumer also they have to file half yearly return. Bulk consumer, which we are not. For example, our university. For a university, it's a bulk consumer. We procure a lot of techs. We procure a lot of batteries for our running those inverters, and also we do also have to file half yearly return. I remember when I was preparing this green audit for our university, I prepared a questionnaire, and in that I in fact remember we have to also mention whether university in fact file any half yearly return to that. So we are a bulk consumer in a way. So this is something which is also a responsibility of a bulk consumer. The 2001, when it comes to 2016, it's more or less same. In fact, if you refer to Rule 4, it also makes a duty of every occupier of an institution generating biomedical, generating, these so-called, I'm so sorry, these recycle batteries wastes. And this is somewhere, it's a responsibility upon the authorities at the same point of time, as I have already discussed. But, you won't find major such difference between the 2001 and 2006. But primarily, the basic factor that you will come across is that the conditions that have been prescribed with respect to the batteries, wastes, and all, they have in fact complied. In fact, these 2000 rules was of course in accordance with the Environment Protection Act and Section 6, 8, and 25 of Environment Protection Act. So anyone who violates the 2001 rules, it's kind of applicable. So, but when it comes to 2006, they have also kind of moved ahead, and they have also fixed the responsibility of manufacturer, importer, assembler, and reconditioner to ensure that these used batteries like the lead acid batteries are collected back and sent to the authorized recyclers. So there is this duty to create public awareness through advertisements, publications, posters. And here in the 2016 rules, they have emphasized on when they are going ahead with awareness, they have to emphasize on the hazards of the lead. They have to also ensure that the awareness is also directed to generate a sense of responsibility amongst the consumers to return their used batteries only to the dealers which are registered, or designated collection centers. And at the same point of time, they have to also make them aware of the addresses of the dealers and designated collection centers, which I was mentioning, that many of you are not even aware that where is the collection center in Guwahati, where are the collection centers in your part of the town where you are staying. So these are the three important aspects which in fact they have emphasized that this should be the part of the 2016 rules. However, if you go to Rule 4, as I was mentioning a while back, the manufacturer, importer, assembler, and reconditioner, they must also use the international recycling sign on the batteries. So this is the 2016 fact that even the manufacturer, importer, assembler, reconditioner have to use it. Previously only with the recycler, but now even they have to use that recycling sign if they are using the recycled batteries. In fact, it has also fixed a responsibility, a liability, not responsibility, I would rather say liability on the dealers, recycler, consumer, even bulk consumer, auctioneer for proper collection, use, transportation, return of used lead acid batteries to a designated person, which can be, of course, a dealer or a manufacturer, importer, assembler, registrar, recycler, whatever it is. Now, the thing is that with respect to the authorities that we have the SPCB, for example. The SPCB shall also appoint an authority to look after the proper compliance of these rules, and this is as per Rule 12. So, as per Rule 12, if SPCB is not doing it by itself, the SPCB can also appoint an authority, and the recycler must also possess environmentally sound facilities for recycling and recovery. So, this is what it is in the 2016, which is quite akin to that of the 2001 rules relating to batteries. The next one is the Chemical Accidents Emergency Planning, Preparedness and Response Rules of 1996. I'll just mention the key features of this particular rules. In fact, this basically deals with the duties of authorities and occupiers in the event of any accident which involves fortuitous or sudden or unintended occurrence while handling any hazardous chemicals, resulting in continuous, intermittent, or even repeated exposure to death, injury, or to any personal damage of any property. There is a 4-tier system that they have done under the Chemical Accidents Rules of 96. There is a central crisis group, which is, of course, to be set up by the central government, which is an apex body to deal with all the major chemical accidents, and it will also provide expert guidance on handling such chemical accidents. In the event of accident in a state, the body is to render financial and infrastructural help also. The central government shall also set up a crisis alert system as per this particular rules, which shall be setting up the control rooms in such places as it deems fit. The second is the State Crisis Group, which is to be constituted by the state government. It is the apex body within the state to deal with and provide expert guidance for handling major chemical accidents. Here, the state government shall also constitute district and local crisis groups. Here, the DCG, for example, and LCG, so-called the district and the local crisis groups, they are the export bodies to handle all major chemical accidents within districts, and the local at the very local level. Now, the thing is that this body shall also assist in preparation of a district off-site emergency plan and review on-site emergency plans, which are usually prepared by the occupier of the major accident hazard installations. These bodies are also responsible to assist in the preparation of, the district one, responsible for district off-site emergency plan and review of the on-site emergency plans. And finally, when it comes to work with the district administration, of course, it is required. So district collector and all, they should be also aware of what DCGs doing and all. When it comes to the LCG, so-called the local crisis group, this body in each industrial pocket has to deal with the chemical accidents and coordinate all the efforts in planning, preparedness, and mitigation of a chemical accident. I don't know how many of you are aware of it. This 4-tier system, on paper and principle, appears very, nice, and it's a crystal clear representation of our federal structure. So it's pretty much there. It's not that we don't have good rules and regulations. It's already there in place. But how far the coordination happens, that's a major challenge. I at times wonder, one district collector, he's part of so many bodies. He's taking care of Forest Conservation Act, de-reservation identification, recognition of the rights. He's also taking care of the forest rights of the scheduled and other traditional forest dwellers. He's part of disaster management body in his district. He's part of these kind of other authorities, which in fact is also working in tandem with several other authorities. So one individual, so many responsibilities. Well, that is also something which I believe they are also trained to handle, and this is how it is. So, but they cannot work until unless all these specialized bodies and groups are working in coordination with the district administration. So that's why that is also quite significant. They are also, same way the LCGs also prepare local emergency plan, not planned, local emergency plan for industrial pocket and ensure what, the dovetailing of the same with the district emergency plan. So this is with respect to that. And if so requires, on request, the respective crisis group shall also provide information to the public regarding any chemical accident, preventing preparedness and mitigation to the living or functioning under that particular area of the jurisdiction. So this is with respect to the chemical accident rules. The next one is the electronic waste management and handling rules of 2001. I understand I am trying to bring all these rules under one roof and sharing it with you in one video lecture. I completely understand it takes a lot of time and effort to read and understand. So I'm trying to just bridge them and present it in a platform so that you have some idea about it. And your interest, I believe your interest, because you have a lot of time these days, your interest will drive you to that. And instead of me spoon feeding you, I insist that you will also I expect that you will also refer to these rules out of your own and go through these rules and regulations and see what are there in place. But I'm pretty sure whatever I'm trying to portray over here, already gave you and still giving you some clear idea about the entire functionality and the structure of the skeleton of the waste management and handling rules of our country. The next one is the electronic waste management and handling rules, which I believe you should be all aware of because you're all using electronic equipments. Now, there are also certain duties for the producers under the Electronic Waste Management of 2011, and in fact, just like those others, the Electronic Waste Management and Handling Rules also came across with certain amendments lately, and it was in the 2016 when the electronic waste management rules were also amended. Now, when it comes to this electronic waste management and handling rules, there are certain duties upon the producers. In fact, these duties are basically to collect the waste which are generated through production. Uh, and this waste generated at the very end of the life of their products. They have to also set up collection centers like those other legislations, and financing and organizing the systems and the costs which are required for environmentally sound management and informing the public about these. Creating public awareness about the systems are pretty much required. Now the thing is that when it comes to yeah, electronic waste management of 2016, the thing is that under if you go with the definition, please refer to Rule 3, Clause R, which defines electronic waste as a waste, electrical and electronic equipment, whole or in part, discarded as waste by the consumer or bulk consumer, as well as rejects from manufacturing, refurbishment, and repair processes. In fact, there is something called triple E, right? We. So if you refer to Rule 3, Clause P, it defines electrical and electronic equipment as those equipment which is dependent on electric current or electromagnetic fields in order to become functional. In fact, the 2016 rules also goes in the same alignment because not much which you find as kind of different. But there is a provision for obtaining no objection certificate from the State Pollution Control Board for transportation of any electronic waste, and also to intimate the State Pollution Control Board of that particular state or the state of the transits. So, with respect to the duties of the producers, also you have to ensure that the producer has to ensure that they are responsible for the collection of the waste which are generated. They have to also ensure the setting up of collection systems, financing and organizing the systems, and the costs which are required will be borne by them, and it should be in an environmentally sound manner. And they have to also inform the public about these electronic wastes, generating awareness just like the batteries. Now, when it comes to the duties of the collection centers, along with these so-called producers, the collection centers also have certain duties. Now, what are the duties that they have? With respect to the duties that they have under the 2000 and the previous one, this is not 2016 but the 2001 rules, they have the duty to inform the public about itself and ensure that the waste which is collected is safely stored before it is sent to a registered recycler. They too also have to file annual returns in Form 3 to the SPCB of the respective state. Now, there is also a duty of the consumers. Now, when it comes to the duties of the consumers, basically, we just like you and me, just the way we have seen it in case of the batteries, waste management, and handling rules. There are some things which are also there with respect to the 2016 electronic waste management rules. So here also the bulk consumer means the bulk users. They have to also ensure that they are dismantling, giving it to proper collection centers, their equipments and all. And the bulk consumers are also to maintain records of the waste which is generated in Form 2. Now here I would like to highlight one crucial flaw that I have done while discussing about it. The batteries waste management and handling rules It was not amended in 2016. It was my mistake. It was only enacted in 2001. I mean, it was not amended in 2016, unlike others. I just missed it out. So the one that I was referring, it was 2001 only, not 2016. So that's why I got a bit confused about it. I'm sorry about it. The thing is that when it comes to these electronic waste management or hazardous waste management or even plastic waste management plan, they were amended in 2016. However, the batteries waste management was not amended in 2016. So we still have the 2001, which is pretty much functional. There are certain responsibilities of the dismantlers and recyclers also. They have to obtain authorization and registration from the State Pollution Control Board in accordance with the procedure which is there under Rules 9 and 11. They have to also ensure that no damage is caused to the environment during storage, transportation, or even dismantling of electronic wastes. When it comes to authorization, all the producers of this equipment, which are listed in Schedule 1, the collection centers, the recyclers, the dismantlers, they have to obtain authorization from SPCB. The other thing is that when I'm referring to all these things, you must be wondering that why, I mean, the same repetition. Of course, the thing is that more or less all these waste management and handling, they have a kind of a common procedure. They have a common, quite similar responsibilities and duties upon all these stakeholders who are involved in that. The only thing is that if you refer to those respective forms, they're with respect to specifications of the waste that you are generating or transferring or recycling or whatever it is, the specifications are different. Otherwise, the basic skeleton is similar. It's similar. In fact, see, the decision on the application has to be made 90 days of submitting it. The same kind of limitation period is also there with respect to other waste management. So there are so many, right? In fact, I got confused and I, by mistake, said that 2016 batteries, but it was only 2001. I presumed it. The thing is that this application, so when you refer to these rules and regulations, I insist you refer to the basic one which I have mentioned in my lectures, and after that refer to the 2016 rules, so that you can also draw some comparison between the same. And waste management rules is pretty huge, to be very honest. So I'm not expecting you to be an expert overnight. So one after the another, you pick one waste management. You start with hazardous waste management, and or maybe you can pick electronic or even plastic waste management, which is very interesting read. So there also you can refer to the same and accordingly go ahead, and you will find that there is a common factor which is there. The cradle to grave approach is there with respect to all the waste. It's just with respect to the specification, the nature of the waste, few things are different. Even the storage and transport of electronic waste. See, these producers, collection centers, dismantlers, recyclers, they may store the electronic waste for a period of not exceeding 180 days. So this was not there for batteries. I mean, these time period that they have mentioned over there, but there also they have certain specifications with respect to, guidelines with respect to provisions with respect to transport of batteries, storage of batteries. It's there. So similarly with electronic waste, they have mentioned it as 180 days. Now, the rationale behind this is based on scientific inputs. Here also they have to maintain a record of collection, sale, transfer, storage and segregation of wastes. Here also they have to kind of report it to the State Pollution Control Board, and it's the State Pollution Control Board which in fact may extend this particular time if they want to keep the electronic waste for more than 180 days. Then they have to take permission from SPCB, and SPCB will issue this no objection certificate. And no objection certificate was also, NOC was also issued under hazardous waste management rules, if you remember. Even for accident reporting, see, all of them have to report if something goes wrong, be it hazardous waste, be it batteries waste, be it electronic waste, be it plastic waste. Not plastic waste, but chemical accidents. They have to inform the prescribed authority. And most of the cases is the State Pollution Control Board or committees in the union territories about that. Even in case of transportation of electronic waste for dismantling or for recycling in a state other than the state where the waste is generated, the the transporter, they shall give prior intimation to the State Pollution Control Board of the concerned state or the SPCP of the state of transit. So this is like informing them about the same, whatever they are transferring from one state to another state. When it comes to biomedical waste management and handling rules, this is quite interesting. Why is it interesting? Well, from the perspective of what we are facing up lately, hygiene is something which is very important. In our day-to-day life, we have this domestic hygiene taught to us, right? But if you go to any of those medical institutions, where diagnosis, treatment, immunization is all happening, right? Be it related to us, be it related to animals or any other research activities, things are quite different, right? So if some harmful microorganisms, bacteria, virus, or whatever it is, uh, if it gets all out in the air, then you know what happens. So, with respect to biomedical waste, the reasonable care is again necessary, but the stakeholders are a bit different here. Here you have occupiers. Occupiers are basically what? Those institutions which are into human health, either into animal research or veterinary, right? So, these are hospitals, nursing homes, clinics, dispensaries, veterinary institutions, animal houses, pathological laboratories, blood banks, even up to certain extent slaughterhouse. But the thing is that the biomedical waste management is all about treating and disposing of a different kind of waste which has a potential to cause human damage to human health, right? Of course to environment also. You know why? I'll tell you why. Like for example, animal houses, right? When animal houses and slaughterhouses, the most of the time you will find the slaughterhouses, they face the problem because see, they sell the skin, right? The leather and all. Then for meat and all, of course they are going ahead. Now the only thing which kind of remains and which no one buys is the blood from these slaughterhouses, and they contaminates the water. So this is the thing. So that's the reason. So there are many such issues which in fact the type of the waste is also different. So that's why the occupier, they have to set up within the time schedules prescribed in schedule 6 of the biomedical waste management, and that's how they have to go ahead and do the same. There are several other duties just like this, like for example the containers where in which they are transferring those transporting the waste, they should be kind of properly labeled. Untreated biomedical waste shall be transported only in such vehicles which are authorized for the same. No untreated biomedical waste shall be kept stored beyond 48 hours, right? In electronic waste it was 100 and right, so it's more than 100 days, but when it comes to untreated biomedical waste, not more than 48 hours. So if any reason is there to believe that the storage is required beyond the time, then authorization is also required, just the way it was there for the electronic wastes. However, the rules, it doesn't apply to occupiers of clinics, dispensaries, pathological laboratories, blood banks providing treatment and services to less than 1,000 patients per month. So those institutions which are providing services to more than 1,000, only for them the biomedical waste management and handling rules is applicable. Otherwise, for the rest, it isn't. Now, in addition to that, you should also keep in mind that just like those others, the biomedical waste, the authorized persons of biomedical waste management, they have to maintain records and an annual report also for the same. Here, with respect to BMW, I mean biomedical waste management, 2016 witnessed one amendment. And this biomedical waste management rules 2016 is basically applicable to all those persons who generate, collect, receive, store, transport, treat, even dispose of or even handle biomedical waste in any form. And they have defined biomedical wastes. And for that, you have to also refer to Schedule 1 of the same. In fact, Rule 4 makes a duty of every occupier of an institution generating biomedical waste, which also includes hospitals, nursing home, clinics, etc., to handle the wastes in such a way that it shouldn't cause any adverse effect on human health and environment. And the thing is that they have clearly specified the biomedical waste management should not be mixed with municipal solid wastes. That is also there under the same. In fact, Rule 8, it also provides for the segregation of these wastes, the biomedical waste, in different colored plastic bags. And they should be labeled. And that has been also specified under Schedule 1, Part 1. They should be packed safely. And these wastes shall be transported only in authorized vehicles. And no untreated biomedical waste shall be kept beyond 48 hours, as I've already mentioned. Further, you can also refer to Rule 14, where they have kind of repeated the same thing which is there in other waste management rules, like proper record should be maintained with respect to generation, collection, reception, storage, transportation, treatment, and disposal of biomedical waste. And all these institutions, they are under an obligation, in fact, to report any accident of these particular sites of biomedical waste. which they are handling or transporting to the prescribed authority, which usually is the State Pollution Control Board. So more or less, they are all same. There are also certain powers and duties, just like the others. The prescribed authority, on receiving an application under Form 1, shall also make enquiries if they are satisfied that the applicant has the capacity to handle biomedical waste. Only on the basis of that, they will grant, renew authorization. Authorization can be cancelled if they fail to comply, and reason of cancellation must be in writing, and suspension must only be done after hearing the occupier. Natural justice principle. So, see, these are the things which are common. So, if you read just one, it will be applicable for all. I'm not expecting you to be very technical and specifically mention Form 1, Form 3, Form Schedule. Even I cannot. But the idea is that if you refer to the same, just to gain the idea, I'm pretty sure it will be impregnated in, it will be imprinted in your brain. But I'm not expecting you to get it by heart. But the thing is that to get an idea, what is it all about? The difference, the area of difference, the area of similarity. Mostly area of similarity. Divergence, pretty less. In between 2001 2016, there was 2003 amendment rules, which in fact gave birth to this advisory committee, and it was the Ministry of Defense which kind of constitute this. This advisory body is basically, with respect to all these healthcare establishments, they have to advise the Director General Armed Forces Medical Services, AFMC Pune, you know that, right? And Ministry of Defense in the matters relating to implementation of biomedical waste management. In fact, Rule 9A was inserted, which gave the Central Pollution Control Board the power to monitor the implementation of these rules with respect to armed forces healthcare establishments, which was not there previously. Now, armed forces healthcare establishments have also been brought under the biomedical waste management rules, especially after the amendment of 2003. Recycled plastic manufacture and usage rules is 1999. This is the old one. Now you have the plastic waste management rules of 2016. In fact, if you refer to the same, there was, I remember this recycled plastic management and usage rules of 1999. Way back, it was Honorable Minister, the then Jairam Ramesh, who in fact released these rules. He in fact stated that it is impractical and undesirable to impose, and I quote, sorry, it is impractical and undesirable to impose a blanket ban on use of plastics all over the country. The real challenge is to improve municipal solid waste management systems. And in addition to the privatization and mechanization of municipal solid waste management systems, we must be sensitive to the needs and the concerns of lakhs and thousands of people involved in this informal sector, unquote. In a way, he gave the picture that, well, plastics, if you're talking about banning it absolutely, think twice, because this is related to informal sector, this is related to livelihood, this is related to labor laws. So, in a way, in fact, it was an indication that it's not going to happen, maybe. I remember even in the initial point of this year when there was a fuss, and I think by end of 2019 there was a lot of fuss about banning plastics everywhere, and for a couple of weeks it was so strict, stringent, up to this micron you can, beyond that it can't be. I was pretty much happy up to a certain extent. However, I think Jairam Ramesh was right in a way. So the 1999 rules were something which in fact highlighted obligations of the manufacturers. With respect to carry bags, containers which are made of plastic shall be of natural shade and white color. These carry bags and containers made of recycled plastics and used for the purposes other than storing, packaging foodstuff shall be manufactured using pigments, colorants, as well as, in fact, if I'm not wrong, even after 2016, there were certain amendments which occurred, which specifically mentioned about the thickness of these so-called plastics. And in fact, if you refer to that, the local bodies, there is a state level advisory body also, and at the same point of time, the local bodies in the urban areas, they have been also conferred certain responsibility under the 2016 rules. Like, for example, they have to ensure safe collection, storage, segregation, transportation of these plastic waste. They have to ensure that no danger is caused to the environment while you cover this entire process. They have to also ensure that you are setting up collection centers for plastic waste. They have to ensure channelization to the recyclers. They have to create awareness. They have to engage agencies and groups. In Guwahati, for example, with respect to municipal solid and also for plastic, I believe, several NGOs, more than 30 odd NGOs, are engaged by GMDA and JMC. And they are the one who collect the waste across the city.
So, in fact, they have to the local body in the urban areas. They have been given the responsibility to ensure that the open burning of the plastic waste is not permitted. And we have seen how far the truth is. In fact, you remember I referred to one case law also in the initial point of time. It was a daily case law, if I'm not wrong. And when it comes to these retailers and the street vendors, right? Well, the 2016 rules was clear that they are prohibited to sell and provide commodities to the consumer in carry bags and plastic sheets. However, the thing is that when it comes to local authorities, the gram panchayats are also responsible for ensuring the implementation of municipal solid waste and plastic wastes. But at the end of the day, when it comes to you and me, we are all doing it. We are all not carrying our respective bags. There are certain general conditions also which were there under Rule 5, Clause D, for example, with respect to storing, packing and selling of gutkhas, tobaccos, pan masalas. Well, those who are chewing gutkhas and I feel sorry for them, but at the same point of time, especially after pandemic, I'm pretty sure it will be banned for some time. So it's not good for health. At the same point of time, it's also not good for the environment because there also you're using plastic materials and sachets basically. But as per Rule 5, Clause D, the thing is that as per 5D, the storing, packing, and selling of the gutkhas, tobaccos, even pan masalas, which use plastic materials in their sachets, it's banned. It has been banned, but still it's happening. I believe even the BDs and all, they're still selling it in plastics because once again, informal sector, livelihood, cannot deny that. In fact, the foodstuffs which in fact are engaged in, in fact, the foodstuffs which will not be allowed to be packed in recycled plastics or even in combustible plastics, as per Rule 4F. Recycled carry bags shall conform to the specific BIS standards, Bureau of India standards. Even the plastics carry bags, which you are carrying, it should either have the natural shape, only with those pigments and colorants which are in conformity with the bar that has been prescribed by the Bureau of India standards. Once again, IS 98331981. So, when it comes to marketing and labeling, also the rules made it quite compulsory that each plastic bag and multi-layered plastic pouch shall be a name, registration number, manufacturer of the bags, thickness of the carrying. So next time when you carry or if you find any, just see it's written over there. I have seen it. The bearer, the name is there, the registration number is there, manufacturer is there, the thickness of how many micron is it. It's mentioned there. And it will also prescribe that it is in strict compliance with BIS specification, IS 14534, 1998 or 11198, something like that. And at the same point of time, it kind of mentioned that this is in guidelines of recycling of plastics. It's there. Just watch it. In fact, if you want to refer, please refer to Sarita Agnihotri's case. Sarita Agnihotri versus State of Madhya Pradesh. The Madhya Pradesh High Court, in fact, issued 23 guidelines for implementation of these plastic waste management rules. In fact, the Honorable Court got to know that the environment as a whole and the wildlife of the state was particularly affected, seriously affected, adversely affected because of its indiscriminate use of polybags. And that's why the court took a note of it and wanted to ensure, and that's why it issued 23 guidelines. In fact, the court directed the government to constitute that authority which they should have done as per the old rules, the 1990 rules, the recycled plastics manufacture and usage rules. But, well, how far it is, that is something which we have to see. And even the certificate of registration should be also in conformity with the Water Act and the Air Act. The Municipal Solid Waste Management and Handling Rules is quite significant, and it applies to all the municipal authorities who are responsible for collection, transportation, disposal, processing and all. Just like all the other authorities, the municipal authority plays a very significant role with respect to the solid waste management of our country. And here you will also find the district manager or the deputy commissioner or the secretary in charge of Department of Urban Development is responsible for compliance. The municipal authority or the operator of the facility, they have to also make application under Form 1 for granting authorization for setting up a waste processing and disposal unit at the same point of time. I've just realized that I use same point of time more often in my lectures. I should refrain from doing so. Even in 2016, the solid waste management rules, the amended version came. But prior to that, you will find that all these authorities, in fact, the municipal authority has the duty to report to the district collector or DC, right, with respect to municipal solid segregation, storage, disposal, collection, treatment of landfill site, transportation, etc. Municipal authority, as I've already mentioned, plays a very significant role here. The municipal authority is bound to report the accident to Form 5 to the secretary in charge of the urban development department. So here you will find municipal authority playing a very key role. The Central Pollution Control Board, with the help of state pollution control boards and several other committees, must also review the implementation, standards, guidelines, compilation. It's compilation. Sorry, compilation of compilation of monitoring data that is also there. In fact, in municipal solid waste management rules encountered another amendment in 2016 prior to 2016 2013, which is basically applicable to every municipal authority which is responsible for segregation, storage, collection, transportation, processing, and disposal of municipal solid waste. And if you refer to that, you will find that its definition of municipal solid waste has been emphasized, give them a very inclusive definition, like includes the commercial, residential waste generated and the municipal or notified areas in either solid or semi-solid form, excluding the industrial hazardous waste, electronic waste, etc. And if you want to refer to the responsibilities under Rule 5, the responsibilities of municipal authorities are there. Under Rule 6, the responsibilities of SPCB and PCCs are envisaged, and responsibilities of the CPCB under Rule 7 and State Level Advisory Board under Rule 10. Even under the Water Act, you will find that it also prohibits the discharge of pollutants, right? If you remember, I've already discussed that the CPCB laying down standards refer to Section 24 of the Act, which in fact clearly prohibits the discharge of any poisonous, noxious, or polluting matter into any stream or well. Section 25, in fact, provides that no person can establish or expand any industry, operation, or process, or operate any such process which is likely to cause discharge of sewage or trade effluents. When it comes to 2016 rules, in fact, there are in total 37 duties that have been prescribed as per Rule 15. And in fact, the Gram Panchayats and the municipal, below municipal, like local authorities are responsible for the same. Like, for example, they have to prepare plan for solid waste disposal, they have to arrange door-to-door collection, they have to establish a system to recognize organization of waste pickers, they have to frame bylaws, they have to direct waste generators for like not to litter, burn, or bury wastes. They have to also establish waste disposition centers for domestic hazardous waste. They have to ensure safe storage and transportation of domestic hazardous waste. They have to provide training to the waste pickers or the rack pickers. They have to waste pickers and waste collectors, not rack pickers. Sorry, they have to collect waste for vegetables, fruits, flour, etc., on day-to-day basis, and promote setting up for a very decentralized compost plant or composting, which is also known as composting. And of course, they have to also phase out the use of this chemical fertilizers in 2 years. That is what they have said in 2016. Along with that, they are also responsible to allow only the non-usable, non-recyclable, and non-biodegradable, as well as non-reactive and non-combustible inert waste and pre-processing rejects and residues from waste processing facilities to go for sanitary landfill. The local authorities are also required to involve communities in waste management and promotion of home composting, biogas generation. In fact, with respect to transportation of segregated biodegradable waste, there are certain specifically mentioned responsibilities upon them. They can also frame bylaws and prescribe criteria. In absence of potential biomining or even bioremediation of dump sites, they have to like scientifically, take some approach. Now, very beautifully in these rules, they have given all the responsibilities. I wonder, and I, with all due respect to the authorities out there, I wonder and I sincerely doubt how many of them are well versed with these rules. How many of them are in fact aware that they have the responsibilities or even powers? How many of them are well versed with the science behind it or assisted or rendered any assistance as regards the same? So once again, in principle, it's very beautifully drafted. To be very honest, I mean, if you want to look into very critical, angle of it, I'm sure you will get. But if you see the outline, it appears very beautifully drafted, considered all the facets. Unfortunately, never sees the light of the day because of the lack
of awareness amongst the people who are involved, the authorities, in fact. You're talking about Gram Panchayat, involved in so many responsibilities here, right? Are they really equipped with this information or equipped with the knowledge? That is something, and before generating awareness amongst the people at large, I think they should be made aware, they should be equipped. Only then it can be handled, right? In fact, with respect to this, Supreme Court has also declared in NC Mehta versus Union of India case from 2016. The citation is 2016 Volume 4, Supreme Court Cases 269. I repeat, 2016 Volume 4, Supreme Court Cases 269. The Supreme Court has declared in that particular case that the local bodies and other institutions which are involved in generating solid waste must take necessary steps to ensure that no part of such waste is burned, and proper arrangements are to be made for disposal of such waste in a scientific manner without causing hazardous thing to the environment. Nothing new, but the fact remains, are they equipped infrastructure wise, technology wise, knowledge wise? And this is something which we have to see. There are several such judgments which came across, like Charan Lal Sahu, for example, Almitra Patel's case. I insist you look into Almitra Patel's case. Look into the Charan Lal Sahu case, which is also known as the Bhopal gas disasters case. And at the same point of time, see, I again use same point of time. You should also refer to the Research Foundation of Science versus Union of India case, which was with respect to hazardous wastes. Now, these laws have created certain impact. They have reiterated the precautionary principle. For example, the Law Citizens Forum and Enviro Legal Action case, which reiterated these precautionary principle, environmental measures, and application of precautionary principle and polluter pays principle, fixing absolute liability, even for Taj trapezium case. Despite these things, even with respect to Almitra Patel's case, with respect to waste management, to be very specific, guidelines, directions were given. Unfortunately, we are yet to achieve that zenith of waste management in our country. Hopefully, whatever I have discussed, I'm pretty sure it's mammoth size and I have clubbed it all together. But I believe you have time in your hand and you will refer to these rules. I'm pretty sure you will also point out several flaws. Even through this lecture, I also have mentioned that, remember the biomedical waste, which was not amended, it was only 2001. Because so many, I myself got confused. So, but still, your interest will definitely drive you if you wish to look into it, because it's all related, and at the same point of time, it will bring everything to ground zero, where you as an individual are also one of the stakeholders in more or less all these forms of waste management. So in next class, I'll discuss some other facets of environmental law. Until then, take care of yourself, take care of your family, stay home, stay safe. Thank you very much.